Good afternoon, everyone, and welcome to an Olive Branch's webinar on ethics in American Buddhist groups. Today's webinar is on the subject of governing a spiritual community. My name is Catherine Weidman, and I'll serve as moderator for this webinar. And the webinar is being supported on the technical side by Leslie Hospodar. An Olive Branch was founded in 2011 primarily to respond to conflict and ethical misconduct that seemed to be sweeping Buddhist communities in the United States. Our organization hopes to preempt severe conflicts and misconduct by teaching dispute resolution and strengthening board governance. And in cases where conflict and misconduct are already in full bloom, we respond with processes for healing and restoring harmony. Before I introduce today's speaker, there are three things I want to mention. First, the webinar is being recorded, and the recording will be posted on the Olive Branch website as soon as possible following the webinar. Second, participant microphones are muted. With nearly 50 people attending, it's not possible to have an open phone line for everyone. And then third, if you have questions along the way, please enter them in the question box on the control panel on your screen. We will pose your questions to the presenter during the presentation rather than holding them to the end. Questioners will not be identified by name. Today's presenter is Ellis Carter, attorney and founder of the Carter Law Group in Phoenix, Arizona. Her firm advises nonprofit, tax-exempt, and mission-based organizations with respect to corporate, tax, and regulatory issues. Today, you're going to learn about the board's fiduciary duties, effective oversight, conflict management, and much more. At an Olive Branch, we believe that the incidence of severe conflict and misconduct can be significantly reduced by strong board governance. And if these dysfunctions do occur, good governance practices and policies can support resolution. That was certainly the case when we at an Olive Branch became acquainted with Ellis for the first time. We had taken on a case involving alleged sexual misconduct on the part of a spiritual leader. Ellis was the attorney for the complainant's organization. So as the case developed, we had several opportunities to consult her. A major asset of this organization was their governing documents and policies, which Ellis had prepared for them when the organization was founded. So with this brief introduction, I'll turn the presentation over to you, Ellis, and we'll be interrupting from time to time as participants post their questions. So, Ellis, take it away.
Thank you. And I was very surprised and pleased to find out that a group such as the Olive Branch existed, because there's certainly a lot of organizations that run into these types of conflicts and don't want it to necessarily turn into a legal battle. It's helpful to have someone who understands their culture and their traditions to help them resolve these kinds of issues. So, first thing I want to discuss is to talk about the regulatory climate for nonprofits and how it's really changed and evolved over the past 2 decades. Starting in 1997, some very strict rules were put into place to deal with financial misconduct for nonprofits called the excess benefit transaction rules. In the early parts of, I think around 2000, the Sarbanes-Oxley, all of the various scandals leading up to Sarbanes-Oxley really shined a microscope on nonprofit governance practices as they were evolving and changing in the for-profit world. Board members who were undergoing all of these changes in their for-profit companies started to apply some of the same concepts to the nonprofits they were involved with, and various state governments followed suit by passing laws that really tightened up governance for nonprofit organizations. And at the same time, the standards and expectations within the IRS and other regulatory bodies, attorneys general, and also various standard-setting organizations for nonprofits evolved as well. And so what really happened is the nonprofits used to be considered regulated, but they've really moved to a highly regulated industry in the last decade. And certain types of nonprofits are among the highest regulated as far as, I would say, schools, charter schools, hospitals, some of the highest regulated industries in the United States. And so it has put an additional burden and raised expectations for board members. We see a lot of scrutiny, as I said, from Congress, the AGs, the IRS. The IRS has made it their policy to increase audits of exempt organizations. They've been talking about that policy shift for years, and we are really starting to see the results of it. Myself and many of my colleagues are now seeing more audits of nonprofits than we have ever seen in our careers in the past couple of years. Additionally, journalists love nonprofit scandals. They never want to report about successes, of which there's so many, but they love to find out about nonprofit scandals, and they're always willing to listen to whistleblowers and try to turn something into a juicy story that will garner lots of clicks and eyeballs. So that's something nonprofits need to be especially aware of, especially since a lot of their information is more public than for private organizations. So with that in mind, with this particular audience, I wanted to talk about the need to separate spiritual and secular roles.
So Ellis, this might be a good time for me to interrupt with a question that came in last night already. So I'll just go ahead and read it, and I think it's really germane to this particular topic. So the question goes like this. In Tibetan Buddhism, there are concepts of samaya, sacred bond, pure perception. Among other things, samaya involves doing what the teacher says, and pure perception involves seeing everything the teacher does as pure and as a teaching. Most people with governance responsibilities and leadership roles in Tibetan Buddhist organizations have this kind of commitment with the teacher who leads the organization. How can it be possible for them to react appropriately when someone complains, for example, that the teacher has sexually abused them, or if the teacher fails to operate within the laws which govern such organizations?
And I think that's always going to be an inherent tension between, for Buddhist organizations, between their spiritual roles and their legal obligations. I think that tension will always exist, and the best that a board member who is also a student of the spiritual leader can do is to try to strike a balance. Ultimately, even though the board members may be used to showing deference to the spiritual leader, the legal obligations that are imposed on a board member in the United States are not going to defer to Buddhist tradition if there is a serious legal violation. And so the board members have to understand they can be held personally liable, as can their spiritual leader. And so by they're going to have to be able to sort of set aside their student role and put on their board member hat to exercise their fiduciary duties. Doing so protects the organization, it protects the board members, and ultimately it can also protect the spiritual leader, especially if they're innocent of the charges, or if there's maybe just a misunderstanding about what the standards are under the law in the United States. And if they can't reconcile those roles, then it's probably best to let someone else serve on the board who feels they can better balance those roles. Ideally, the organizations would find some independent board members who are not students, although I realize that's probably a major challenge, because what motivation would someone who's not involved with the spiritual aspect have to serve on an organization that is essentially a spiritual organization? But that would be ideal.
Another question has come in, Ellis. I don't know if it relates to the topic of separating spiritual and secular roles or the topic of the regulatory climate, but the question is, what about the lesser degree of regulation for religious nonprofits?
There are some advantages that religious nonprofits have over other types of nonprofits, which is they do not have to file a Form 990. They don't, if they're a church, they don't necessarily have to file, or of the equivalent of a church, to be a temple or something like that, then they don't have to file for tax-exempt status even. But that doesn't necessarily mean that they don't have to follow the law. They're still subject to the same laws. They can't self-seal. which means essentially inappropriate use by the insiders of assets. And sexual harassment is still, all of those laws still apply. So there's a bit more privacy for churches and temples, and they don't have to they don't have to be quite as transparent as other nonprofits, and they don't have to put out quite as much public information. But ultimately, the laws still apply to them.
Thank you.
So, and certainly fiduciary duties are governed by state law, and most such organizations are probably set up as nonprofit corporations. And so the fiduciary duties we're talking about today are the general fiduciary duties that apply under state law to nonprofit corporations. They're expressed slightly differently in different states, but the gist of it is what I'm going to talk about today. So the key fiduciary duties are basically good faith, due care, and loyalty. And directors accept potential liability for failing to fulfill their fiduciary duties. So it's important to understand what those are and to have those sort of top of mind at all times. And to understand that in a nonprofit corporation, the board is ultimately responsible for the organization's performance. The idea of fiduciary duties is that if you fulfill them, you get a legal shield for the board members to protect them from personal liability. However, if you violate or ignore fiduciary duties, plaintiffs can use anybody who is suing you or trying to what we call pierce the veil of the corporation to reach the assets of the individuals involved with it. They will be looking for instances where you have breached your fiduciary duty or failed to fulfill them so that they can go after board members personally. So this is really, fulfilling fiduciary duties is a protection for all of the directors and officers. So it's important to understand that in discharging your duties, you don't have to personally do everything. No one has time for that. You don't have to go over every tiny entry in the books. You don't have to, personally eyeball everything that happens in the organization. You're allowed to rely on others in certain circumstances. You're allowed to rely on your accountant and financial statements that are prepared. You're allowed to rely on opinions from your attorney or other professionals that have a specific expertise. However, if you know that their advice is wrong because they didn't have all the facts or something of that nature, then you're not going to be able to rely on that advice. So this is what we talk about, the Kinley, Jeff Skilling, this was what was the name of the company? I'm sorry.
Enron.
Enron, right. At the heart of the Sarbanes-Oxley case was that they tried to pretend to be ignorant of what was going on within the company when they were the leaders of the company, and that's never a defense. And a lot of people are surprised that ignorance is not a defense if it's sort of reckless and willful. So it's important to provide oversight so that you can know what's going on in the organization. Go ahead.
A question came in related to that last topic. It is rare, isn't it, for a plaintiff to successfully pierce the corporate veil in a nonprofit case?
I'm sorry, can you state that again?
It is rare, isn't it, for a plaintiff to successfully pierce the corporate veil in a nonprofit case?
I think it's fairly rare in nonprofits and for-profits. However, I have a file of cases that I've kept when it does come up, because there are cases that it's usually pretty egregious, where something pretty egregious has happened, but it does happen. And so, and a lot of these cases get settled. We see cases where a plaintiff tries to pierce the corporate veil, and if the nonprofit knows that they don't have a good defense, a lot of times there'll end up being some sort of a settlement. So you'll never see it in the reported cases. And so even though you don't see very many reported cases where a nonprofit's corporate veil is actually pierced, it does happen. Some states it's harder than others. In some states you just have to see, a breach. You'll see, and there's different standards if you're looking at getting from one corporation to another versus getting from looking at the corporation to looking through to the individuals who are making the decisions. for the corporation, the directors and the officers. So while we don't see that many reported cases, we do see quite a few attempts to pierce the corporate veil and a lot of cases that get settled. And so it's still a major concern, I think, for nonprofits.
Thank you.
So different ways that that a board can provide oversight to help fulfill their fiduciary duty of especially due care is to review the financial statements, pay attention, make sure that if there's a risk that the organization won't be able to pay its obligations as they become due, that the board takes some sort of action, that if you're not going to be able to make a payroll, then you're going to have to lay somebody off. It's actually illegal in many states not to pay someone their salary. And we see that happen a lot of times where nonprofits will just tell their employees, we'll pay you as soon as we have the money, and they've actually committed a legal violation in those cases in most states. So you have to, if you have a case like that, you have to stop incurring additional obligations and take some decisive action. It's also important to implement policies and procedures, and we'll talk about some of the most helpful policies in a minute. Also, holding the executive accountable for especially operating within a budget that's been approved by the board and meeting any key compliance deadlines. There probably aren't that many compliance deadlines for most of these groups since they don't have to file a 990, but there are some, and they're important, especially with your state agencies. And then also evaluating the board committees, and the chief executive. And I realize in a lot of these groups that may be the spiritual leader, and perhaps it's not appropriate to evaluate them in their role as a spiritual leader, but if they are also serving as the chief administrator or the executive director of the nonprofit, then it is appropriate to evaluate how that's going and determine, whether there are deficiencies that need to be addressed. And then also, boards can delegate power to committees and get regular reports of their work. You're allowed to delegate tasks to different individuals and to committees, and receive reports, and that's considered a manner of oversight. However, you can't delegate the oversight itself. So the board always has to stay sort of in the know and with their finger on the pulse of what's going on, even if they're not personally doing the activity. So it's important to get reports back from those committees about their work and the decisions that they're making. And on that note, it's also important to record the work and what's being done at the committee level. A lot of times we see organizations that do a good job of keeping minutes, but they fail to record any minutes for their committees, and that's something that's very helpful if there's some sort of an audit or some questions raised. It's helpful to have some sort of record about the committee's work. So one tool that I recommend for our clients is to keep a board action calendar, and we recommend that this document be kept at the very first page of the board book or minute book, and it should be just a calendar of key compliance deadlines and also governance obligations. So any filing deadlines for annual reports or solicitation registrations, when you want to have your strategic planning session, when you're going to review your bylaws, review policies. A lot of times there'll be a conflict policy. There has to be an annual disclosure. Those types of obligations should be kept in a single place where all the board members have access to, so they can sort of keep focused on those sorts of duties. Also, the time that you're going to review the annual budget and approve the annual budget, any other key issues that come up for your individual organization, it's a good idea to just keep a list of that and keep it front and center for board members to ensure none of those obligations fall through the cracks. And we're also big proponents of policies for nonprofits. And a lot of times the policies, the bylaws, the details really don't matter until there's a dispute or some sort of a problem, and then they matter enormously. so it's important to have policies can be a roadmap to resolve conflicts and can help sort of head off problems of the past. And so while most of the policies won't come up in everyday conversation and won't be of much import if everything's going well and everyone's getting along and there aren't any serious issues or disputes, once there is a dispute, they're extremely helpful and important. So some of the key, there's a number of policies that we recommend for most organizations, in part because the 990 asks about some sort of obscure policies that may not apply to Buddhist organizations. So I think we have a policy package of like 12 different policies. But for Buddhist organizations, I would say the key policies to consider are the conflict of interest policy, the confidentiality policy, and a whistleblower policy. So the conflict policy is really, it's not legally required, but it's for almost a de facto requirement in today's environment. The IRS asks about it in the 990, which I realize you guys don't have to file, but most states mandate a conflict process, which is very similar to the IRS mandated process, and so it's really an expectation. And conflict policies are helpful because they are just great at ensuring it doesn't matter so much that you have a conflict. Everybody has conflicts. The question is how you manage them. And so being able to, if a question comes up or there's a some sort of a potential scandal, being able to say, look, we handled it in this way where the person who had the conflict disclosed it to the rest of the board, the independent board members met and made a decision, and here's what they based their decision on. It's very helpful, and it gives the organization a good story to tell, and it ensures that their decisions are made without bias. So that's a really, really important one. Also a confidentiality policy. We have found having a confidentiality policy to be extraordinarily helpful when some sort of a dispute or issue breaks out and creates tension on the board. Because a lot of times if there is disagreement at the board level, then having it, people will want to, well, they'll be angry if they don't get their way, and they may want to go out and breach confidentiality and talk about what's going on to outsiders. And really that's a breach of a fiduciary duty. That's a breach of the duty of loyalty to the organization. And so it is a board, out of your duty of loyalty, should keep sensitive board matters confidential because it can be very damaging to the organization. It can create potential legal liability. It could create suits for defamation. It's just very, and it also could damage the organization as far as, depending on what's going on, if you're disclosing donor information or other sensitive information. So we think it's important to have a confidentiality policy. If no dispute ever arises, it may never be needed, but if something like that does come up, then we have found it to be extremely helpful as a reminder of that duty to the people who are involved and may be tempted to undermine the organization with loose talk. And then finally, a whistleblower policy. It's important to have in place some sort of a mechanism for people who have had, are aware of some maybe financial misconduct, maybe it's some sort of sexual harassment or inappropriate conduct. And a lot of times, if there's an important leader of the organization who's involved in the misconduct, then it will never be reported because anyone who might report it to the organization is afraid of retaliation. So it's important to have a whistleblower policy that says, here's how you report misconduct that you're aware of, and if it involves any of these people, here's an alternative route of who it can be reported to, and also should give the whistleblower anonymity. It's really important that if something is reported that they not retaliate against a whistleblower, because even if an allegation of misconduct turns out to be false or untrue or mistaken, the very fact of retaliation, especially in a discrimination type case or some protected class, the very act of retaliation is a separate cause of action that can get the organization in trouble.
So Ellis, I have two questions that have come in on this topic, and then one that will definitely be here on your in the next topic coming up. So
Okay.
let me go back, and one quick clarifying question when you were talking about the conflict of interest policy is, are you talking about conflict of interest or dispute resolution?
Well, I'm really talking about conflict of interest here. So I think that having the conflict of interest policy helps you avoid legal violations. So when people make decisions that are biased in their own interest or in the interest of somebody close to them, that's more likely to result in some sort of what we call private inurement or excess benefit, or somebody being overpaid for the work that they're doing, or something of that nature. And so really the conflict of interest is supposed to help ensure that decisions are made in the best interest of the nonprofit and not in the interest of any influential person. And so, but it doesn't necessarily address conflict resolution.
Right. And I would say that an olive branch certainly strongly recommends a dispute resolution or a grievance procedure of some kind, but that's not the same thing as a conflict of interest policy.
That's not the same thing, yeah.
The person asking this question could certainly Google conflict of interest and find a great deal of information about it. And it's kind of the same with the other question having to do with that previous topic was, how do you define good faith, due care, and loyalty? Mm-hmm. So if you looked up
well, I can cover that really quickly. I mean, good faith is really honesty in purpose and honesty in fact. At least that's how it's been defined in Arizona. And loyalty, I think, is really with the interest, prioritizing the interests of the organization over any personal interests, doing what's best for the organization over not only over personal interests, but interests of other third parties. And that can create conflict when maybe someone is on the board of two different organizations that are transacting with each other. That creates, a conflict, and often to avoid breaching a duty of loyalty, that individual should recuse themselves from any transaction involving the two things that they are interested in. And then, I guess, due care is ordinary care and prudence that you would exercise over your own affairs. And so, if somebody makes a whistleblower report, and if it were your own business, you wouldn't necessarily just go to the person who's accused and they'd say yes or no, and you would end the inquiry there. You would probably have some sort of an investigation or dig deeper, and that's what is expected in your role as a board member. So really to apply the same diligence and due care that you would to your, to any other business. And a lot of times I think nonprofits get sloppy about that, and they hold things to a lower standard because they're not the owner. Nobody owns the nonprofit. They're just a volunteer board member, and nobody likes to ruffle other people's feathers or make anybody mad. They all just want to get along. And so there tends to be a tendency to be a little bit lazy about these things and think it doesn't matter as much. But really your duty is to run the organization and with the same level of care as you would if it were your own business.
So, okay, thank you. We're ready to go to this slide, standing up to authority figures.
Sure.
Go ahead and ask the question that came in a little bit ago about it.
Can you ask it, because I actually don't have access to that screen right now.
Some Tibetan lamas believe that having sexual relationships with some students is beneficial for the students, regardless of what the relationship looks like or what the woman says afterwards. How should boards respond to this?
I think perhaps in that regard they need to educate the Tibetan Lama about the differing legal standards in the United States and cultural expectations. That what may be acceptable in Tibet is not going to be acceptable here in the United States, and so they're going to have to treat their students in the United States and their organizations in the United States differently, because that could create real legal liability for the organization and for individuals and for the Lama, the Tibetan Lama themselves. So this question comes up with nonprofits of all kinds, the concern about standing up to authority figures. Sometimes some boards tend to show excessive deference to the board chair, the executive director. It can also be a spiritual leader, a founder, and this can lead to the directors abandoning their fiduciary duties. This is popularly known as founders syndrome. There's an actual word for that, and you can Google it, and all kinds of articles will come up on founders syndrome. But we periodically are faced with nonprofits that come to us where there's typically it's a founder, not always, but an executive director or CEO who absolutely believes the nonprofit is theirs, that they get to make all the decisions, that the board is really just there as sort of decorative, and they don't have to listen to the board. And we've been in some really just shocking situations where the executive director just simply does not understand the lines of authority, doesn't understand their role, and has to be removed. And so that's sort of an extreme example. But it's important for everyone involved to sort of understand the lines of authority, and that, you know, no one owns a nonprofit. There's no one committee, no one director, not the chair, not any individual, not even a spiritual leader individually can control the organization. So really, it's if your bylaws say that you have to have a majority vote of the board, that's the ultimate authority, and the buck stops with the board, not the executive director or the spiritual leader. And that's in most cases. The only exception is when there's a nonprofit that is set up as a membership organization, and the member may have special rights that can supersede the board's rights, but that's probably not the case with most of these organizations. That's the only distinction I'll make there. So the founder typically acts as the chief executive and runs the day-to-day. And in a situation where there is a founder, founders also often sit on the board. And founders, as I said, tend to you know, in the beginning, they're usually absolutely crucial to the organization, and the organization wouldn't exist without them, so their identity sort of becomes very tied to the organization. But ultimately, the founder also serves at the pleasure of the board, and it's important to make sure that everybody understands, okay, founder, you're extremely important to this organization, and we wouldn't be here where we are today without you, but at the same time, you don't get to make all the decisions unilaterally. This is still a board-governed organization, and the board has to serve its role as well, and so there has to be a balance that is struck there. And similarly, with the spiritual leader, if they're the one running the day-to-day affairs, they may have complete authority over the spiritual matters, but with respect to their administrative role, when they're wearing sort of their executive director hat of the person who is running the organization day-to-day, with respect to that role, they serve at the pleasure of the board. And ultimately, the board is the one making the big picture decisions. And then finally, it's been a little trend in my practice lately where we've seen several cases where we had board chairs who did not seem to understand their role and thought that they're sort of the board czar or something and get to make all the decisions. And really the board chair, typically they're just presiding over board meetings. They're a liaison between the board and the chief executive. They may help shape the agenda for the board meetings, but they do not have a veto. They do not have a unilateral vote. They do not get to override the power of the board and the decisions of the board. So that leads to our next topic, which is asking hard questions. A lot of times we'll see boards that there's sort of a spectrum of boards. There's boards who are what we call rubber stamp boards, who just are very deferential to the executive director or the founder, whoever is running the day-to-day. And then on the other spectrum, we'll see boards who are very micromanaging and make it very hard to run the organization because of their tendency to be micromanaging. So, but on this rubber stamping sort of concern that we have with very deferential boards, is there's a tendency not to ask hard questions. And so I think to deal with that, it's important to set a tone that really encourages discussion and encourages an exchange of ideas where no question is discouraged, and so that people can really have open discussions about issues without any fear of reprisal or of looking silly or having people be mad at them. So I think it's important to set that culture early on so that people feel comfortable asking questions. And ultimately, if you have that free, open, vigorous discussion of issues that come to the table, you're going to get much better decision-making out of that. Which brings us to managing conflicts of interest. So as we talked about conflicts a little while earlier with respect to the recommended policies, conflicts can essentially be with board members, with officers, with significant donors, with really anyone, particularly with vendors and employees and things like that. When you think about it, a conflict is really any kind of anything that comes up that where the person who's making the decision could be influenced by some competing interest. And so even when you're just setting the salary of an employee who's also a director or an officer, that's a conflict. And as I said earlier, conflicts aren't bad, and people sometimes are intimidated just by calling something a conflict as if the organization has done something wrong, and that's really not the case. Every nonprofit has conflicts. The key is in how you manage the conflicts, and regulators are far more interested in the process you used to resolve a conflict or to resolve a transaction that involves a conflict than they are in the actual result. If the process that you used to make the decision was well managed to eliminate bias, they're going to be far less likely to attack the result or the actual decision itself. And so, as I said, there's such an expectation of conflicts of interest policies with the IRS, with various state laws, and with nonprofit sort of standard-setting organizations. It's practically a de facto policy or de facto required policy. And so really everyone, if you don't have a conflict of interest policy, you should get one. And that's one of the most important policies that you can have in your policy manual. A good source for policies would be BoardSource. I believe it's boardsource.com. Has all kinds of sample policies available. So the key is that it would govern any transaction between the corporation and interested persons. And that can be selling, leasing property, paying compensation, lending or borrowing funds. And really most of the policies that you'll see out there will focus on financial transactions, but there's also non-financial things that may be relevant to your specific organization. So we sometimes see groups amend their policies or customize their policies to cover things like political concerns and allegiances, or if they're a grant-making organization, to deal with the fact that a person on the board may also be on the board of a potential grantee. And there could be religious concerns, I suppose, as well, that could come up in a conflict policy. So it's important to think through what are the different conflicting allegiances or biases that could impact decision-making in the organization, to see if there's anything else besides just financial that you need to think about in your conflict policy. So the key methodology that's really required by by the IRS and by pretty much any state that's addressed it to manage the conflict, the three things you need to remember are the person with the conflict needs to disclose it to the rest of the group and then recuse themselves, which means they take themselves out of the decision-making process and they permit the decision to be made by disinterested, independent people that are part of the decision-making body that do not have a conflict. And then once that occurs, they have the disinterested, independent members need to think about, okay, if it's a transaction with an insider or someone who's related to the insider, what are the alternative arrangements that they could be entering into? And if they decide to go ahead with the conflicted transaction, what are the reasons that made that the more attractive option for the organization? And I see this happen all the time. It doesn't really bother me when we see conflict transactions, as long as this process is followed and the board clearly articulates, well, here are the other options, and here's why we think working with this insider makes the most sense. And a lot of times it does make more sense to work with an insider. They have more knowledge of your organization and more a higher understanding of your needs, things like that. But you really have to weigh, you know, those factors against the price and their ability to deliver and all of the other factors, and then clearly write it down in the minutes so that you have some protection if the decision ever gets questioned. You can say, well, here's the process we relied upon, here are the factors we considered, and here's why we came to the decision that we did. And then if it does get questioned, the organization has a good story to tell, and the board should be protected because that's a clear indication that they exercise fiduciary duties in making that decision.
So Ellis, I think I'll jump in here for a moment. We have another question. I'm not sure exactly where it fits, and we'll also point out that we have a little less than 20 minutes left. So
okay.
The question is, are there any particular issues you would highlight for nonprofits set up with voting membership?
If you have voting members, and voting membership can really run the gamut as far as how much autonomy or how much control or influence the members have. So you can have voting members who only vote on one narrow thing a year, or maybe they don't vote on anything unless the board asks them to vote on something, or maybe they have an actual legal right to determine who the directors are each year, to remove them, to replace them, to approve major transactions. So there's a spectrum of how much deference they may give to the board or how much power the members have. If it's a case where the members hold a great deal of control, that doesn't really relieve the board from any of their fiduciary duties. And if the member is not personally involved in the decision making, that means that none of this really changes. But if you have a member who has the type of control, or some members who have the type of control where they can come in and remove directors, replace directors, then that ultimately, if there is a major dispute at the board level, then the members at least will have the option to come in and deal with it without it having to go to court or something like that. So that can be a good thing, but you can also see major disputes develop at the member level. We see a lot of groups that want to get rid of their voting member structure. And if they have a large membership class, they might have trouble getting enough members to show up to meetings, to have a quorum. So that can be problematic as well. It doesn't really change the duties of the board, though. It just means that there's another sort of tribunal to take things if they can't get worked out at the board. It really depends on the governing documents for the organization, since member rights can be very different from group to group.
Thank you.
So with that, I'm going to move on to awareness of laws. And I'll try to go quickly since we're getting towards the end. So everyone needs to understand that because tax-exempt organizations have all kinds of tax benefits, the IRS requires more or imposes more rules on tax-exempt organizations than they do typically on for-profits. And so some of the bare minimum things you need to understand is that there are consequences for overpaying key employees. That's an excess benefit. If you engage in excessive lobbying or get involved in politics at all, you can lose your tax-exempt status. If you make really bad bargains, basically draining the money, the organization's funds for private interests, that can also get the organization in trouble and threaten tax-exempt status. So there's all kinds of legal protections to stop people from exploiting the assets and the tax status of nonprofits. And so it's just important that boards periodically get some training on what some of these basic rules are. Also, keeping governing documents up to date, especially for these groups that are member-driven. Their documents are going to be far more complicated. They may need to have member meetings in addition to board meetings, and there's just a lot of complexity there. There's lots of groups that come to us that are so proud that they've been in existence since 1960, whatever, but they haven't looked at their documents since that time, and like the corporate code, at least in our state, has been repealed and replaced more than once in that time, and the tax laws have all changed dramatically. I mean, you have to, maybe not every year or even every couple of years, but periodically your board needs to review the governing documents and make sure that they match how you're actually operating today and that they are still up to date with state law and federal law. We also see a lot of times, the mission and purpose in the original documents evolves over time, and that never gets looked at, and pretty soon you're not operating within the parameters of your governing documents. So, putting down and putting it on the board action calendar that you review the governing documents maybe every 3 or 4 or 5 years, just at some regular intervals, so that doesn't happen, I think is helpful. And also to make sure people are reviewing the documents every time they're electing officers or directors, creating committees, just to make sure that you're operating within the rules that are there. One other point is that even if you had no bylaws, or if your bylaws are extremely brief and don't cover everything, everyone has a set of rules they have to follow. You have default bylaws in your state corporate nonprofit code. And most of the nonprofit statutes around the country will have a set of default rules that can be altered by the articles and bylaws. But if your bylaws are silent on an issue, then you have to look to the state law. So I oftentimes see boards that will spend a year or more trying to work out these bylaws, but they never go back and look at what state law says. And so there's some things you can alter, there's some things that you can't, but it's important that they mesh well with the state statute that governs nonprofit corporations. And so key things you want to include in your bylaws: you want to address the governance structure. Is the organization a board-driven organization or a member-driven organization? You want to have control provisions as far as what power different groups have. Do the members elect the board? Does the board elect themselves? Is there some outside third party that appoints board members? You want to address the director's terms, officers, how they're elected, what are their terms, voting provisions, what is the quorum, what is the vote that's required to pass a resolution, committees, how do you create a committee, what are the rules for committees, address conflicts of interest. We often just refer to an outside policy because there's sort of more than, we used to put those in the bylaws, but as the law and expectations evolved, we find that the policies need to be longer than what can neatly fit in the bylaws. And also how you go about amending the documents. You want to leave out any information that will change frequently, because it'll just, if you're too specific in your bylaws, then you're going to have to amend them all the time, and that's unnecessary. So if you don't need to have long procedures in bylaws. Those can be in a separate manual or in a board resolution or something like that. It's just really the key information that's not going to change frequently that should be in the bylaws. And also any detailed purpose and activity descriptions, those are not necessary in the bylaws, and since those things tend to evolve and change frequently, it's best to leave them out. We see a lot of groups with ambiguous member provisions. If you say you have members but you're not clear on whether they're voting or not, state law may give the members quite a bit more power and authority than you realize. And if the members become dissatisfied with the board, some boards have been unseated because of powers that they had no idea the members had that were because of ambiguous member provisions and relying on state law. And then requirements to follow Robert's Rules of Order. I always counsel groups to leave those out. Those are written for legislatures and parliaments, and this is
Leslie, we seem to have lost audio.
Yeah, I can hear you.
We
Ellis?
lost Ellis then. Yes?
You did.
There's a thing on her up on top. Does that show anything?
I just sent her a message.
Sorry, everyone. Please stand by. We'll try to get our presenter back.
I will jump in then just for a minute on this. The Zen Center of Pittsburgh has run with a consensus decision-making. I think nonprofits are often destroyed by voting. I believe that working through different viewpoints can create really wonderful solutions to problems. Perhaps it's on a building. If you vote up or down, many people will be so dissatisfied they might leave your organization. But bringing all the different viewpoints together can create a really strong movement forward to create a much more out-of-the-box thinking. And I highly recommend people think about switching the bylaws to a consensus decision-making.
Thank you, Kilke. Let's see if Ellis is back now. I see the slides advancing, but I don't hear any audio yet.
Do we have any other questions that you have out there, Catherine?
I have one that I need to have Ellis answer.
Okay.
Catherine, I've passed back to you.
Okay. So I'll circle back, even though I don't have the slide up. I know that Ellis's last point there was about maintaining confidentiality. I don't know if you remember the photograph of two women kind of talking, whispering back and forth, gossiping, it looks like. And I'll preface my comment by saying that I'm a certified governance trainer, so familiar with many of the points that Ellis was making during her presentation. And I know that in this last topic about maintaining confidentiality, she was wanting to remind everyone that part of being on a board and following the fiduciary duty of loyalty is that board members must adhere to a duty of confidentiality. And what that means is that once an issue is discussed and settled by consensus or a board vote, that everybody who was against the idea still must be a uniform front. You can't have board members going out into the parking lot or meeting for coffee later or going to the paper or the radio station or putting something on Facebook about, well, they said this or they decided that, but I didn't agree, and here's why, and so on and so forth. So the duty of confidentiality is an important one, and many boards have board members sign an agreement to follow a confidentiality policy.
That makes really good sense, Catherine, and I think I've seen work well where there's been a lot of heated discussion around something is for one or two people to be selected as the spokespersons and people to go to in the organization for the decision. And they will talk to the press, they will make the statements for the organization out there, and may actually have a written statement they release for people to talk with.
So that was the last topic about maintaining confidentiality. I mentioned at the outset that the way we at an Olive Branch met Ellis in the first place was in relation to a case we had taken regarding alleged sexual misconduct. And these policies, confidentiality policy and interest and the bylaws and other policies that had been crafted when the organization was founded really seriously did come into play when things went haywire. And just as Ellis was saying, you know, when everything's going fine, you kind of don't refer to these documents, but as soon as there's a problem, you'll be really happy that you have them in your organization. So let's see, I'm looking back at my question screen here. One of the questioners asked if it was possible to have a copy of the slides. I don't know the answer to that without consulting Ellis.
I'm back. Yeah, you guys are welcome to have a copy of the slides to send to folks. That's fine.
Okay, thank you. We'll send them on to everybody that's participating then.
Great.
So Ellis, I don't know when you came back online. I was talking about wrapping up maintaining confidentiality, and we have a question here coming in. What should the board do if confidentiality is broken?
Well, what we sometimes have done, if it's a concern that it will be broken, is to send out a reminder to all the board members or former board members or anyone involved, reminding them of their duty. Hopefully they've signed a confidentiality policy, reminding them that they've agreed to this policy that was adopted. And if they breach it anyway, a lot of times you can send them a demand letter, sort of a cease and desist, to let them know that they've essentially breached their duty and breached the policy, and that you could theoretically sue them if they continue and it damages the organization. And a lot of times, if in cases where this has come up, the person who wants to be able to go around and talk about what's going on internally may even consult an attorney, and we've been able to send the policy, including what the board member signed, to their attorney, who then has to turn around and counsel them with, you agreed to all of this, and here's what you agreed to, and remind them why they have to not talk about internal board matters. So that's actually been incredibly helpful to tamp down that kind of behavior.
Well, thank you very much. And I think we're right up against our stopping time, and we'll need to draw the webinar to a close. So we hope that if you have benefited from the webinar and you would like to be more informed regarding nonprofit legal matters, I can really highly recommend Ellis's blog, Charity Lawyer, which you can find on the Carter Nonprofit Law website. And so on behalf of all of us in Olive Branch, Ellis, I want to thank you for today's presentation. And we also thank all of the participants and ask that you complete a questionnaire that will appear in your inbox shortly.
Thank you so much.
You're welcome.
Take care.
Thank you, Ellis.
So we hope that everyone will join us for our next webinar on ethics in American Buddhist groups. It is tentatively scheduled for Tuesday, March 24th, and the tentative topic is ethical decision-making, a process. We will send a flyer with the information and the registration link when it's ready. So once again, we thank you for attending an Olive Branch's second webinar on ethics in American Buddhist groups, and hope that you'll register for next month's presentation. Thank you.